The marble grandeur of the Supreme Court echoed with silence, the kind that pressed on the chest like altitude. Justice Amy Coney Barrett leaned slightly forward from the bench, her gaze cool and unwavering as it settled on the man standing confidently at the petitioner's lectern. Elon Musk, she began, her voice cutting cleanly through the air, you've stated repeatedly that your satellite network operates beyond traditional regulatory frameworks. And yet, you seek the protections of American law without accepting the full breadth of its responsibilities. She paused deliberately. Isn't this simply a case of exceptional privilege? One set of rules for billionaires, and another for everyone else. The question hovered, heavy and dangerous. Elon Musk didn't flinch. He allowed the silence to stretch a beat longer than comfortable before stepping closer to the microphone, the edges of a calm smile forming. With respect, Justice Barrett, he began, that framing fundamentally misunderstands what's at stake here. This isn't about privilege or seeking exemptions, it's about how outdated regulatory systems are being forced onto technologies that didn't even exist when those systems were created. He reached down and raised a thin packet of papers. This, he said, holding the document aloft, contains internal communications from the FCC, obtained via FOIA, that acknowledge the legal gap in applying 1930s-era communications laws to space-based Internet systems. A ripple passed through the courtroom. Several justices exchanged glances. Reporters scribbled furiously in the gallery. Justice Barrett's expression flickered, just enough to register a calculation behind her eyes. This isn't rebellion against oversight, Musk continued. It's a call for the right kind of oversight. We don't regulate cars with rules written for horses. We shouldn't regulate orbital networks with rules written for landlines. Justice Kagan cut in now, intrigued. Are you saying the FCC moved forward with enforcement despite its own technical advisors flagging jurisdictional concerns? That's exactly what I'm saying, Musk replied without missing a beat. From the bench, Justice Gorsuch leaned forward. And they did so knowing Congress had not authorized such a leap in regulatory scope? Yes, Your Honor. The courtroom's tone shifted, less adversarial, more curious. Justice Barrett glanced at the papers in Musk's hand once more. The battle lines were shifting and she knew it. Justice Barrett regrouped quickly, her voice still firm but shaded now with a note of caution. Mr. Musk, she said, the document you're referencing, those internal FCC communications, they weren't part of the official case record. The court cannot admit new evidence at this stage. Musk nodded, respectful but composed. You're absolutely right, Justice Barrett. But these aren't classified memos or private leaks. They're public records, obtained through FOIA just weeks ago. They aren't new evidence, they're context. They show that even within the FCC, experts acknowledge that current statutes do not clearly apply to space-based networks. That caught the court's attention. Justice Kagan leaned forward. Let me ask this plainly. Are you saying the FCC moved forward with regulatory enforcement while internally doubting its own authority? That's precisely what happened, Your Honor, Musk said, steady. The Commission's advisory committee explicitly recommended congressional action before proceeding. The leadership ignored it. From the bench, Justice Gorsuch raised an eyebrow. And yet the FCC asserted jurisdiction anyway? Yes, sir. In an internal memo, they wrote, and I quote, "We cannot wait for Congress to catch up with technological reality." A low murmur passed through the chamber. For the first time, the weight of Musk's argument was beginning to shift the energy in the room. Justice Barrett tried to recenter the conversation. Your companies have received significant public benefit, government contracts, NASA partnerships. Doesn't that imply a duty to work within existing regulatory frameworks, even if they're imperfect? Musk met her gaze. Of course, we comply fully with valid, applicable regulations. But this case isn't about avoiding responsibility, it's about recognizing when the law itself is no longer fit for purpose. Just as we didn't apply horse and buggy laws to cars, we shouldn't stretch Depression-era statutes to govern orbital systems. Justice Sotomayor joined in. But if we allow new technologies to define their own frameworks, what stops others from bypassing oversight? That's exactly why we've proposed legislation to Congress, Musk replied. We're not asking for deregulation, we're asking for the right regulation. Modern, deliberate, democratically enacted. The courtroom had changed. Musk wasn't just defending a company anymore. He was framing a national conversation about how America should govern the technologies of the future. As the arguments neared their end, the atmosphere in the courtroom had shifted. What began as an attempt to undermine Elon Musk's position had transformed into a compelling debate about the future of legal frameworks in the face of emerging technologies. The Solicitor General rose to defend the FCC's authority. Your Honors, the government acknowledges that space communications present unique challenges, but the FCC has broad authority over all forms of communication, regardless of location, she stated confidently. Justice Clarence Thomas, who had remained silent during Musk's presentation, now spoke. But how do you respond to Mr. Musk's evidence that even the FCC's own advisory committee questioned its jurisdiction? The Solicitor General hesitated, her composure slipping. Those were preliminary discussions, Justice Thomas. The Commission's final determination was that its existing authority applies. Justice Kavanaugh joined the questioning. But isn't that an expansion of power without congressional approval? Wouldn't that violate the major questions doctrine? As the government struggled to defend its position, Musk rose for his rebuttal, now with renewed confidence. Your Honors, this isn't just about satellites. It's about whether we apply outdated frameworks to technologies that didn't even exist when those frameworks were created. That's not a matter of regulation, it's a matter of adapting the law. He paused, looking each of the justices in the eye. When new technologies emerge, we must not allow agencies to retroactively apply old rules. The appropriate response is legislative action, not regulatory overreach. The shift in the courtroom was undeniable. What had started as an effort to portray Musk as seeking special treatment had instead allowed him to articulate a sophisticated vision for regulatory modernization. Months later, the Supreme Court issued its ruling, a 7-2 decision in Musk's favor. The court concluded that the FCC could not extend terrestrial communications laws to orbital networks without clear authorization from Congress. Justice Barrett wrote the majority opinion, emphasizing the need for a careful approach when applying outdated statutes to new technologies. In the aftermath, Congress passed the Space Communications Regulatory Modernization Act, creating a modern regulatory framework for space-based communication systems. Musk's influence on the conversation had been undeniable, shaping the future of technology regulation in America.